because I live there, and I've seen the peel mills operating, and I knew when I was practicing how that worked. I was not surprised to know that there was an overabundance of supply to very small towns that were servicing certainly the vehicles parked in those parking lots had license plates from all over the country. So I was aware of that practice, but I wasn't aware of the staggering numbers until they came in later. Though that distribution, I think, temporarily occurred before the big switch to injection drug use that we saw using heroin, and there was always fentanyl around. But in 2016, something appeared to us to happen in the supply chain, and we saw...
Well, let me just interrupt you. The supply chain of fentanyl is not coming through the supply chain, right?
We're talking about the illicit supply chain.
Okay.
The illicit supply chain of fentanyl seemed to change really remarkably in the second half of 2016, and the entry of the fentanyl analogs really picked up then. That's when we started seeing a massive increase in overdoses and overdose death.
That seems to have been catalyzed by the initial excess distribution phenomenon that was happening in your neighborhoods.
I certainly do not argue with that iatrogenic component that this started with prescription drugs.
I guess our frustration from talking to the DEA on Monday was where it seems like there was a blinking red light on the dashboard. Why didn't anybody check the engine? You know what I mean? I always lived in fear of the DEA when I was in practice. I thought they knew everything about me, every prescription that I wrote, every patient that I treated. Then it turns out on Monday we hear that they really weren't paying that much attention, and it was startling information to me.
Apparently not, but I don't think that we as physicians were as red flagged as we should have been while we were prescribing under the pain as the fifth vital sign rule.
Sir, let me recognize Mr. Green of Texas, 5 minutes for questions. I have some additional questions that I may try to get to at the end, but Mr. Green, you're recognized for 5 minutes.
Thank you, Mr. Chairman. I want to welcome our panel here today. I'm going to thank all our witnesses for joining us. We agree that the opioid epidemic is a multi-sided problem and will require a multi-part solution. As part of the solution, it's essential that we expand access to treatment. We must also identify strategies that encourage individuals with substance use disorders to seek and remain in treatment. I'm concerned that the proposal to roll back protections under Code of Federal Regulations Title 42, Part 2, commonly known as Part 2, would do the opposite. Dr. Marks, in your testimony, you state that if patients with substance use disorders are afraid their treatment records will be used against them, they will not enter treatment. Could you explain the important role of confidentiality plays for individuals with substance use disorders entering treatment and working towards recovery? You want to turn on your mic?
Thank you. It plays a critical role. If you are working to decide whether or not I'm going to enter treatment, whether or not I'm going to deal with the issues that are most relevant in treatment, that's a critical protection to have. We know that folks will not come to treatment if they are afraid of what the impacts will be. So, for example, I worked with parole and probation for quite some time, and there would be some question of, someone goes and they're having a holiday party, and they go and they show up and there's drinking there. Well, not a surprise. but then they start to have cravings. So the work of treatment has to do with having a safe space to be able to discuss these issues clearly and directly without rather having to say, oh no, I didn't have any problems, nothing was going on here, so that for fear that I would disclose it to somebody else. You know, it's a role more like a priest-penitent relationship than just other roles.
Why are the height and protections provided under Part 2 critical to creating the safe environment for treatment for individuals which substance use disorders that you described in your testimony?
It's critical for the safety. One of the key elements in terms of treatment is that there is a therapeutic alliance. And sometimes it takes weeks or months to build a relationship. I've had clients that were with me for 6 months before they suddenly say, all right, now I'm going to tell you the truth about what's really behind this. You know, so it takes time to build a relationship. It takes time to have that safety. And anything that's going to damage that safety, such as fear that this will be disclosed, it will impact that and prevent them from entering or staying in treatment or working on the critical elements within it.
According to a letter submitted to the committee from the Campaign to Protect Patient Privacy Rights, rolling back the Part 2 protections to the HIPAA standard will contribute to the existing level of discrimination and harm to people living with substance use disorder, and will only result in more people who need substance use disorder treatment being discouraged and afraid to seek the health care they need during the nation's worst opioid crisis. Dr. Marks, would you discuss how rolling back Part 2 protections to HIPAA standard harms efforts to create a safe treatment environment and potentially leads individuals with substance use disorders and not to enter or remain in treatment?
Thank you. Many of our folks have dealt with trauma, for example. And so one of the things that's really critical difference in between HIPAA and 42 CFR is that with 42 CFR, when I disclose to my clinician, I know that's private unless I disclose, I sign and get information that it will be shared with somebody else. When I share with my clinician about the sexual trauma and assault that I faced previously, that's a private conversation. And before that gets shared to multiple other people without my knowledge, which is what the standard would be under HIPAA, that's a problem. So when information comes back to me from some other clinician that gets the information from the clinical record rather than having that conversation with me directly when I'm not ready to share it, it's a severe damage to the trust that's needed for a relationship for treatment.
Thank you. I support strongly the efforts to expand access to treatment, encourage individuals to seek remain treatment. I'm concerned the proposed changes to 42 CFR Part 2 misses the mark. And in my last few seconds, in my earlier life, I did probate work. And in Houston, Texas, the probate judges are also the mental health judges. And I was honored, I think, when the judge decided he wanted to appoint me to be on the mental health docket for about 3 weeks. And this was before HIPAA. It was in the 80s. And we still had that protection, though. I don't know if it was under state law or federal law at that time, that even the lawyers had to destroy all our information. And believe me, it would have been really difficult to get people in treatment if they knew that would be available to potential employers. Now, if there's a danger, we all have a responsibility of that, whether you're a medical professional or what. But just that average, letting people know someone's under care, it really bothers me. Thank you, Mr. Chairman. I know I've run out of time.
The gentleman yields back, Chair. Thanks. The gentleman chair recognizes the gentleman from Kentucky, the vice chairman of the subcommittee, Mr. Guthrie, 5 minutes.
Thank you, Mr. Chairman. I appreciate the opportunity to be here and all the witnesses being here. I'm going to focus my questions to direct them to Mr. Bauer, who is from back home. We've had several Kentucky witnesses over the last yesterday and today, and been fantastic witness. It only says that we have a big issue in our state, like surrounding states, and it's spreading. So that's why what we're doing here is so important, to make sure that we move forward. But I'm going to focus on the prescription drug monitoring program. So when providers check their PDMPs or prescription drug monitoring program, to Mr. Bauer, what is the evidence that this actually changes their prescribing or dispensing behavior, resulting in improved patient outcomes and lives saved?
Thank you, Vice Chairman, for the question. Today, with the PDMP programs, the one most impactful issue with the programs is integration of that information into workflow, and we're finding that really helps to enable efficient access to the PDMPs, so the PDMPs are checking. There are 40 states that have mandated use laws in place today, which mandate the checking of the PDMP in one way, shape, or form. So we've seen the use of the PDMPs have an impact on the overall volume of opioids prescribed. We think that's in conjunction with policy at a state level as well. From an outcomes perspective, there are current studies that are underway, one of which is Appriss Health has a study underway to understand the actual outcome of checking the PDP on opioid death, the death curve. So that study is not completed yet. We're about 3 to 4 months into that study.
Okay, thank you. And also, you mentioned that some states are turning the PDMP into a substance use disorder platform. Can you elaborate on what that means and how it would help someone who might be at risk of addiction or substance misuse?
Sure. When PDMPs were first formed many years ago, they were more of a diversionary tool that was used to understand drug diversion. The programs have since morphed into more of a public safety tool. So today, information in the form of data, prescription data, is sent to the prescriber or pharmacist for review. States are now moving past that, what they call the phone book of data, trying to understand within that information what is the issue with this patient or what is the risk that this patient represents from an overdose perspective. And we're moving that into more of a substance use disorder platform to provide the clinicians, the prescribers and pharmacists more clinical information so they can engage with their patient, why that patient is right there in front of them, versus trying to read through a phone book of data in the 20 or 30 seconds that they have. So adding additional data sets such as non-fatal overdose, providing for a referral of treatment while they're in their PDMP, peer-to-peer communication, et cetera, are all clinical tools that are designed to truly engage that patient before they go to an illicit drug event.
Okay, thank you. And I have a final question for you. PDMPs are not only critical to prescribers for identifying beneficiaries that are high users, but also in avoiding potentially dangerous drug interactions. It is my understanding that for the most part, PDMPs are not allowed to have data or are prevented from having data on patients receiving methadone. On the other hand, buprenorphine prescribed in an office-based setting is typically filled at a pharmacy, which is then submitted to PDMPs. So why are methadone and buprenorphine treated unequally when it comes to PDMPs? And can we do anything to include this information but still protect patient privacy?
Thank you for that question. What we find today from the PDMPs as far as collecting that data such as methadone or buprenorphine prescriptions, buprenorphine, for example, is a prescription that is actually prescribed and typically picked up at a retail pharmacy, therefore reported to the PDMP. Methadone, on the other hand, is typically administered within a substance use disorder clinic and therefore by law not reported to the PDMP. So that's the difference as far as why.
Well, could somebody get a methadone at a methadone clinic and also have a prescription for buprenorphine? I mean, or they interact at?
They certainly. The short answer is it is possible.
So I mean, I guess the gist of the question, because I'm about out of time, can we address that with still? I know the idea is for the methadone's patient privacy. Can we address that?
Yeah. Obviously, we want to take privacy into consideration from a PDMP perspective. Obtaining that methadone administered methadone is critical to understanding the overall risk of that patient.
Okay. Thank you. And 5 seconds, I yield on back.
Sure. Thanks, the gentleman. He gets back. Chair recognizes the gentlelady from California, Ms. Matsui, 5 minutes for your questions, please.
Thank you, Mr. Chairman. I want to thank the witnesses for being here today. Dr. Martz, thank you for your compelling testimony. I've been a champion of building greater education and awareness about HIPAA privacy regulations, particularly as it applies to tricky mental health situations, because I recognize the necessary balance between patient privacy and access to information for purposes of quality treatment. I appreciate your nuanced understanding of the importance of confidentiality for patients suffering from a substance use disorder and the different ways that stigma plays into the situation. I'm also sympathetic to the caregivers and doctors who are trying to better serve patients, and to stories of patients who are harmed because the provider didn't have the right information to make the right clinical decision. I'm hopeful that working together we can find the appropriate path forward on this issue. From your perspective, how well do you think patients know their rights under HIPAA and specifically under 42 CFR Part 2 and the recent SAMHSA update?
Thank you for the question. Patients are pretty widely available, and it's usually one of the very first questions that we ask: who's going to get this information? And even if they don't ask that up front, it's our responsibility as clinicians to immediately give them that information about what you're going to be sharing, what are the limits of confidentiality, and what are the conditions under which it would be released or excluded. One of the challenges with the multiple changes we've had in the last year now from SAMHSA is that every time it comes out as a change, we have to identify the regulation, we have to update our forms, we have to retrain the field and have that conversation with the client, which is very damaging to the relationship that's been built.
Right. So the familiarity amongst the doctors and caregivers need to be updated. So do you think it'd be meaningful for HHS to conduct more education and awareness?
Absolutely. Across the field, not only treating clinicians, but also physicians and other allied professionals that are interacting so that we can better coordinate the care. Very often, the problems that are found from confidentiality are really training issues rather than actual burdens.
Well, do you think there are certain situations or circumstances under which sharing a patient's substance use records would be beneficial to their coordinated care? So, for example, in the case of accountable care organizations that are specifically targeting comprehensive services for those with multiple conditions, such as substance use disorder co-occurring with something like diabetes or depression.
Yes, it's very common to coordinate care, and it's actually an expectation of myself and all the clinicians that I've worked with, that we are to coordinate substance use, mental health, medical conditions. The difference is that there is a protected element for them to discuss the private areas, and it's a clinical issue to engage them, to have that trust, to open the relationship and dialogue with the other clinicians and maintain that constant communication.
Okay. Thank you. Dr. Strain, thank you for your testimony. As I mentioned previously, I'm committed to advancing coordinated patient care without sacrificing patient privacy, especially around a sensitive and stigmatized disease. Recently, SAMHSA released some regulations that broaden rules about redisclosure in 42 CFR Part 2. Do you think that it's been helpful to providers? Alternatively, did it go far enough?
So I thank you for that question, Representative. I think that we haven't gone far enough. I think that we need to provide a mechanism whereby information can be more seamlessly shared between providers who are not in a substance abuse treatment program and those who are in a substance abuse treatment program. I think that at the end of the day, I'm interested in seeing us do better in terms of coordinating care across those two foci, and the current barriers make that difficult.
Yeah. So in your testimony, you provided some very compelling examples, particularly if a patient is incapacitated For things like asking patients about a history of substance use, what type of training do doctors currently receive about best practices?
So training by physicians is variable by medical school. There's not a national standard for training, federal standard. But there's increasing amounts of training in medical schools and for physicians in terms of substance abuse and education. And it's a critical part. It's become a critical part, especially in the current climate.
I could see that we need more, probably continuing education about this. Generally, if a patient is incapacitated or unconscious, your testimony implies there's no way for a doctor to know if a patient has a history of a substance use disorder. Is that absolutely true? For example, can a doctor make inquiries of next of kin?
I'm sorry.
Can the doctor make inquiries of next of kin?
Certainly, the doctor can make inquiries of next of kin to attempt to determine that if they're available.
Thanks. I know we're pushing up against votes, so we're another round of votes.
Thank you.
Thank you. The gentlelady yields back. I now recognize the gentleman from Virginia, Mr. Griffith, 5 minutes for questions.
Thank you very much, Mr. Chairman, over here. And I'm going to continue. Dr. Strain, Doctor, you were just talking about what the doctor can find out by asking the next of kin. And one of the issues that we dealt with, not opioid directly related, but dealing with violent tendencies and violence that we were trying to deal with in cures and in some other things, was trying to figure out how we keep privacy for individuals, but at the same time have some family involvement where the family is actually involved in a person's life, because if they have a significant mental illness and maybe also a drug addiction on top of that, it's sometimes very difficult for the family to get information because of the HIPAA laws. So Dr. Martz raises good points, but how do we reach that balance where, particularly if you're living in the home with parents or a sibling, that they can have enough information to know whether A, they're in danger, or B, how they can be of most assistance to their beloved family member?